Void and illegal contract is terms are not certain, object or consideration is unlawful, and lack of enforceability by law. The consideration of an agreement is lawful unless it is forbidden by law, which is not allowed to a party of a contract which is prohibited by a law. Example in the case of He Ching versus Krishnan in 1955. The plaintiff and defendant was in an agreement to sell and to purchase the defendant's rights under the temporary occupation license. According to the Contravent Rule 41 of the Land Rules 1930, no license for the temporary occupation of the state land shall be transferable. Thus, the agreement was unlawful under clause of section 24 as being of such a nature defeat the provision of any law and therefore it's void. Next will be nature as to defect the law. It defines that performance of an agreement which necessarily entails the offence of the provisions of any law. In the case of Tan Bing Hock versus Abu Sama in 1968, the defendant held a logging license in Pahang under the Forest Rules 1935, which prohibited transfer without prior approval in writing of the district forest officer. The defendant agreed to assign his rights under the license to extract timber to the plaintiff. The High Court found that the contract on which the action was instituted was illegal, as what the parties attempt to do amount to defeating the provision of the Forest Rules 1935. The third example is fraudulent, which is consideration of the agreement is unlawful if it is fraudulent. A case that can be related into this example is Palaniappa Chettiar versus Arunachalam Chettiar in 1962, where the plaintiff transferred the land to his son as absolute owner because to avoid certain regulation that prohibits a person from owning more than 100 acres. The father sought to recover the property from son who resisted claim and the claim was failed. To recover the land, plaintiff must rebut presumption. His true intent was not to benefit his son, but to defraud the relevant authority. Since he relied on illegality, the court won't assist them. Fourth is implies injury to person. It defines that causing injury to a person or property of third party is void, cannot be enforced by court. Such in the case of Sheikh Ahmed Al-Habsi versus Putih in 1922. The defendant agreed to sell a property of the plaintiff in which an infant had an interest. The court held that dealing was detrimental to the infant's interest and court struck down the dealing. And lastly, against public policy. Who knowingly enter into a contract with improper object cannot enforce his rights in relation to such contract. A case that can be related into this statement is Pierce versus Brooks in 1861. A contract of hire of vehicle for purpose of prostitution and those involving an immoral promise, such as promises between a man and woman to live together without being married or to pay a sum of money. There are also section 25 to section 31 which provides for other instance that renders a contract void in law. Section 25. Any part of a single consideration, where we can't consider an agreement for an object or any part of object, it's not a law and the agreement will void. In section 26, the agreement made without consideration will void unless the promiser given it freely. Section 27 is an agreement in restraint of marriage, where every agreement in restraint of marriage of any person, whoever is minor and forced, the case will void. Section 28 is an agreement in restraint of trade, where the cases that can harmful to society will be void. This is illegal contract that in any way colludes to damage another's opportunity or ability to carry out a business. Agreement to restrain legal proceeding. This section only rights arising from contract, not to the crime cases. Normally, this agreement will handle by arbitration. Section 30 is an agreement about void for uncertainty. When the agreement is not certain or not capable, it will be void. Because of the uncertainty, the parties will be frustrated and the court will usually not interfere. Lastly, agreement by way of wager. An agreement where says wager can be uncertain event, example of lottery, gambling, and from any games, the agreement will be void. 2. Consequence of void and illegal contract. The Latin word ex turpi causa non oritur actio defines that an illegal activity may not claim damages arising out of that activity. The first case is Ahmad B. Udo versus Ng Ike Chong in 1970. The defendant entered agreement of paddy land for a period of 6 years and 1,500 was paid in with legal document. The defendant was entitled to recover the deposit paid because Section 66 applied when the plaintiff subsequently refused to allow the defendant to fill the land, and inaction by defendant for recovery of sum paid where court held that since the parties were ignorant of the fact that they were executing an illegal agreement. The last case was Yip Mui versus Chu Chin Chua, where when one party unaware of the illegality of the contract, the party able to recover, the plaintiff who innocently deposited money.